Hello, this is the Civil Rights. Section B, Struggle Against Segregation lecture. We're going to hit prioritize Standard Government Civics 48. And objectively, we're going to identify legal precedents that ended racial and other types of segregation. Following the end of Reconstruction, Southern states passed segregation laws that legally separated people on the basis of race, which have been more commonly known as Jim Crow laws. In Plessy v. Ferguson of 1896, the Supreme Court finally heard a challenge to racial segregation laws in the South. Now, the subject matter of this case, Plessy, which was, I want to say like either a quarter or 1/8 African American. He bought a first-class ticket on a train, and then when he went to get his first-class seat, they put him in the back with all of the other African Americans. And he basically said, hey, I paid for a first-class ticket, I should be in the first-class section. And then he went to court. The court ruled by a 7-1 margin, if you love your margins, that as long as equal facilities were provided, racial segregation did not violate the Equal Protection Clause, which is wrong. It's just not correct. This case established the separate but equal doctrine that further encouraged the institution of segregation, which remained in place until the 1950s. In Brown v. Board of Education of 1954, the Supreme Court heard a challenge to racially segregated public schools. The court determined unanimously, so this was 9-0 if you love those margins, that separate is inherently unequal and declared racial segregation in public schools to be illegal. So this case marked the beginning of the end of state-mandated racial segregation policies, with the Supreme Court continuing to further strike down segregation laws, declaring the institution of Jim Crow to be unconstitutional. Segregation laws did not only affect racial groups, but also impacted those of different genders, as was highlighted in the United States versus Virginia, VMI for Virginia Military Institute, 1996 case. The Virginia Military Institute, VMI for short, had a male-only admission policy, and did not offer any similar educational program for any woman in the entire state. The court ruled, this was a 7-1 margin if you love those margins, that the admission policy was unconstitutional and violated the Equal Protection Clause. Virginia proposed creating a Virginia Women's Institute of Leadership, which they would have called the VWIL, in order to keep VMI male only. But the court determined that since the VWIL would not provide women with the same type of rigorous military training, faculty, courses, facilities, financial opportunities, or alumni reputation, and the connections that VMI would afford its male cadets, that women should be allowed to attend VMI also. As a means of providing equal opportunities in education and employment for minority groups and for women that had historically been denied such opportunities, affirmative action programs were created. So affirmative action actually gave preference to ethnic minorities and women in admission and hiring if they were equally qualified to white male counterparts. Now keep in mind, if they're equally qualified, if a white male is the most qualified person for a job, they should still get the job. But affirmative action just says, if you have two applicants that are equally qualified, how about you give an opportunity to the person that historically has never got an opportunity? Since President Kennedy, affirmative action programs have encouraged increased minority hiring in government contracts. Many colleges and universities have adopted affirmative action programs to greater encourage diversity on their campuses. In Griggs versus Duke Power Company of 1971, the court encouraged companies, in an 8-0 decision if you love your margins, to create affirmative action programs to avoid unfairly limiting the advancement of blacks and other minorities. It also ruled that tests given to businesses to decide promotions unfairly were limiting advancement by blacks and women, and therefore those should be avoided when at all possible. While affirmative action provided more opportunities for minority groups and for women, others have claimed that it led to reverse discrimination, which is discrimination against white males, which was showcased in the Regents of the University of California versus Bake of 1978 case, where Bake, which was a 35-year-old white man, right there, was twice denied admission to a medical school that reserved places for qualified minorities as a part of an affirmative action program. Now, what these qualified minorities meant for this university was, okay, we got 16 spots. We need 16 minorities. Just make sure we get some minorities in there. We need 16 of them. Now, at the time, Bake's qualifications, and based on that I mean his college GPA and also his test scores for medical school, your MCATs, exceeded those of any minority students that were admitted in the 2 years that his applications were rejected. So the court ruled in a 5-4 decision that their rigid use of racial quotas had actually violated Bake's constitutional rights. So Bake, therefore, should immediately be admitted to the medical school. The court did say, however, that race could be one of several admission criteria, but not the only criteria. So just this magic random number, this quota, that was not okay. You could consider race, but it couldn't be the only thing you considered. The court has grown less supportive of affirmative action programs over the years, as highlighted in the Adirond Constructors versus Pena of 1995 case, where a contractor submitted the lowest bid on a government highway project, but it was instead given to a small business that offered a higher bid owned by a socially and economically disadvantaged person. Now, if you're not familiar with the way government contracts work, the general logic of a government contract is they say, hey, we need this job done, and then they'll get different businesses to put forth their bids, and whoever offers the lowest bid, meaning the less expense to the taxpayer, that's who the government is supposed to go with. But in this instance, they went with one that was charging more because they were led by a socially and economically disadvantaged person. Adirond Constructors claim the other contractor was selected based on the race of the owner, not because of actually being disadvantaged. So the court ruled in a very close 5-4 decision, if you love those margins, that proof of past injury does not in itself establish the suffering of present or future injury. So this big support for affirmative action has actually been waning in more recent years. All right, this concludes Civil Rights Section B, Struggle Against Segregation lecture. We hit Prioritized Standard Government Civics 48, and objectively now you can identify legal precedents that ended racial and other types of segregation.